Okay, so it is Tuesday, March 18th, and we have a hearing scheduled. The court will discuss the process for resolving the motions 3 and 6. 3 is Spencer's motion for early termination of supervised release, and number 6 is a discovery motion pertaining to that motion. To join the telephone hearing, please dial 650-479-3207 and enter access code 23159967380 pound. Press pound when prompted for an attendee number. Person's granted remote, so I'm going to call that now.
Welcome to WebEx. Enter your access code or meeting number followed by pound.
Let me enter that number in now.
Enter your attendee ID number followed by pound. If you do not know your attendee number, press pound to continue. You'll now be connected to the meeting.
Okay, so I'm currently on mute. I've muted my phone. It says I'm connected to the meeting. It's 9:27. It's 9:32 for the record. $9.35 for the record. Case number 20 CR 00697, 936 for the record. We are connected to the telephonic hearing, and we are awaiting the court to address us. I'm going to refresh the docket and just see. Last thing found is still number 17. Motion by John Anthony Spencer for evidentiary hearing. Postmark.
Good morning, it's Mark
3-5.
Packold. Good morning. The United States District Court for the Northern District of Illinois is now in session. The Honorable Martha M. Packold, citing 20 CR 697, United States versus Spencer. If you can state your names for the record, we'll start with Government Counsel first. Good morning, Your Honor. United States. Sorry, we couldn't hear you. Good morning, Your Honor. Ashika Desai on behalf of the United States.
And I'm John Spencer on behalf of myself.
Good morning.
Good morning.
And good morning, Judge. Hi, Judge. This is Leslie Cole on behalf of Probation. Good morning. Is there anyone else who would like to enter an appearance? Sounds like we have everybody. Okay, so we're here, or I initially set the hearing to address Mr. Spencer's per se motion for early termination of supervisor release, which is docket 3. Since then, there have been additional filings by Mr. Spencer at dockets 6 and then dockets 8 through 17. Actually, it's dockets 8, 9, 10, 12, 13, 14, 15, 16, and 17. There's also a letter from Sarah Newcomb, which is at docket 11. Okay, so why don't I, also just reviewing the record, I see that supervised release is scheduled to terminate as of, if I'm understanding correctly, it's scheduled to terminate in May of this year. It was a 5-year term of supervised release, and I believe it's scheduled to end on, at least according to docket number 1, which is the transfer of jurisdiction form, where this case was transferred from the District of Minnesota for supervision. The dates of supervision that are listed on that form are from May 12, 2020 to May 11, 2025. So it appears from that document that the supervision expires by its own terms as of May 11, 2025. Today, of course, is March 18, 2025. So there's been already most of the 5 years of supervision have passed, and we're approaching the scheduled end of supervision in a little less than 2 months. I'm not sure what order would make the most sense to proceed in, but perhaps because Mr. Spencer, it's your motion for early termination, it makes sense to start with you and then turn to probation of government, or in either order, to add anything they would like. So why don't I first just ask you, Mr. Spencer, to basically summarize the motion and offer any argument you would like.
Sure. As it stands now, I've gotten nothing other than an email from Leslie Culp on March 6th that says they intend to oppose my motion. That's the only thing in writing that I really have that says that. So I made my motion for early termination of supervised release on the fact that it's almost up. I have completed most of it under 100% compliance. And it was only when I asked about early termination on October 7th that the drug test issue even came up. I consistently told them that it was from legal hemp products. I was told things like that didn't matter. So the test came back positive for THC. I was threatened with a violation. I was told to sign some confession forms. I was given 90 minutes basically to sign these things. If you look at the confession forms themselves, it's clear on them that I denied the violation. I continued to ask for the logic, the rationale for this THC ban. Never got any, not until the March 6th email. I still don't have anything that says that I violated my conditions. I've let them know at every opportunity from October 6th on, and we're all the way in March now. So why, I'm here having supposedly to defend against a violation that's, never been formally, alleged against me. I haven't been able to see any of the toxicology reports. And, I'm asking the court to release me from my supervised release as soon as today. If they wish to contest it, then I wish to, if they try to say that I did a violation or something, then obviously then I have to contest that. I think that that's factually erroneous. I think that there's nothing in my conditions that create this THC ban. So, if I have to get into that, I will. I don't think the burden of proof is on me at this point. It's on them. So I would just ask that they don't oppose my motion and you release me from my term of supervised release for good behavior. The fact that I don't see what the point of keeping me on for another 54, 55 days, what is that realistically going to do except hold me back and create more problems? I don't see the benefit to anybody in doing that. And so, unless they, I guess, tell you that they're going to oppose it and that I did, in fact, violate a specific condition, I don't know that we need to get into that. But, the burden of proof, I would say, would be on them at that point to prove that. I don't know how they could possibly do that, but, that ball would be in their court, I suppose. Can I leave it there and you can come back to me based on if you have any questions? I don't know what else to say at this point other than that.
Yes, that's fine. I don't see any violation reports. Typically, if probation were going to report a violation, there would be a violation report that was filed on the docket, and there hasn't been one filed. So I don't know. I mean, I'll give the government and probation in either order an opportunity to respond, but or, make any comments if they wish. But which they're, yeah. But there is no. Just to be clear, there's no reported violation that's on the docket.
Okay, noted. Thank you for clearing that up.
Okay.
Leslie, would you like to chime in?
Yes. This is Leslie with probation, Judge. So you're right.
Yes,
you're correct, Judge. Yes, you're correct. There was never a violation filed against Mr. Spencer. Mr. Spencer understood that we would not be filing such violation whenever he called on October 7th following our meeting to admit to illicit drug use, taking gummies with THC. I thanked him for his admission. We discussed how that goes against his terms and conditions and how he would cease the use of such. I let him know that we would not be filing a formal violation. However, this goes against his terms and conditions. We would not be setting him up in random drug testing. However, he was still subject to drug testing moving forward. He thanked me. He understood everything. At least I believe he did. And then when he came in February, he inquired again about early termination. I let him know that we could not support probation, could not support early termination at that time because he had the positive UA for cannabis within a 5-month period of asking for early termination. I did let him know, however, he could still proceed with asking the court for early termination, regardless of probation's position. So that's where we're at. He did ask in February for a copy of UA results. I let him know that belongs to the court. He would have to ask the court to release such records to him.
And Your Honor, if I may, this is Asha Givasai for the government. The government is given probation's position and their continued supervision of Mr. Spencer. We have been, Ms. Culp and I have been in contact, and the government's position is the same as probation at this point. Mr. Spencer has tested positive for illegal drug use and THC, which means he's not in compliance with his current conditions of supervision. While the government understands that he has demonstrated compliance with his conditions of supervised release throughout the majority of his term thus far, the fact is that he was not currently compliant when he was tested back in October. And so the government does not support the early termination based on that basis alone and in conjunction with probation's recommendation here as well.
Okay. Any further comments from Mr. Spencer?
Sure. I don't know if this would be the appropriate, forum for me to cross-examine, my accusers. But, I would say that my supervised release conditions by law have to be construed narrowly. That's my understanding. And you can't just graft in anything that you want. And they gave me a reason in the email, and they pointed to some specific provisions. None of them create a THC ban any more than they create an alcohol ban. It says that the defendant shall refrain from unlawful use of a controlled substance. The defendant shall submit one drug test within 15 days of release and at least 2 periodic drug tests thereafter as determined by the court. They never got court permission for any of their drug tests. And they claim that there's a condition, special condition B maybe, where they talk about substance abuse and treatment and things like that. All of those things were handled in Minneapolis. It was determined that I didn't need substance abuse. I was on color code. I had more than 3 drug tests that I passed. This drug test never came up until after I asked about supervised release again. And this is after probation ignored me for almost 2 years. So again, I would say, despite what the government just said, and the fact that I feel strongly that if we have to do a hearing, I can easily prove what was said, exactly what was said. And there's no condition that prohibits this. They chose not to investigate. They told me to get rid of the THC, the legal THC. And now here they are maintaining that I violated, but they're not willing to officially file a violation. So, Judge, I want you to notice that and grant my motion for early termination, because I think it's equitable. It's really equitable based on the facts. But I guess if, we have to go ahead and do this, then at some point I'm going to need to put my accusers on the stand and, really factually develop this. But I think that's pretty silly for 50 some odd months left, or for 54 odd days left of supervised release. I don't think that it's a factual dispute either. I think it's a legal one. The conditions of release don't say that. They didn't ask the court for any of their drug tests after the third one, and it's debatable whether they had to get court permission for the first couple, just by the reading of the actual document, which I'm willing to argue, and I have argued in my pleadings. But for those reasons, and they're saying that they did not file a violation, this is just their position, I would say that, by a preponderance, that it would favor letting me go for the reasons that I said and just what you heard from them today.
Okay, I just want to clarify, there's not going to be an opportunity to cross-examine. That's not a typical...
Well, if you're accusing me of violating and having a controlled substance, I just thought that would entitle me to cross-examine my accuser, just under the Constitution. But if I'm wrong, then, I'm wrong, and I'll have to figure out how to do it, in a permissible way. But, I feel pretty strongly about the facts that I'm declaring under penalty of perjury here in my pleadings.
Okay. So, if, for example, there was a revocation of supervised release, then you would have an opportunity to present evidence. We would hold a hearing. You'd have an opportunity to appear and present evidence. You would have, upon request, an opportunity to question any adverse witness, unless the judge determines that the interest of justice does not require the witness to appear. That's all under Federal Rule of Criminal Procedure 32.1. The 2 capital C. It's an opportunity to appear, present evidence, and question any adverse witness unless the court determines that the interest of justice does not require the witness to appear. And similarly, if probation were requesting a modification, then under Rule 32.1C1, it says before modifying the conditions of probation or supervised release, the court must hold a hearing at which the person has the right to counsel and an opportunity to make a statement and present any information in mitigation. But again, here there's just not a request to modify the conditions of supervised release, nor is there a request to revoke supervised release. What we have here instead is a motion for early termination of supervised release. And that is governed by 18 USC 3583 E. So that says modification of conditions or revocation. The court may, after considering the factors set forth in section 3553A1, A2B, A2C, A2D, A4, A5, A6, and A7, 1, terminate a term of supervised release and discharge the defendant released at any time after the expiration of 1 year of supervised release pursuant to provisions of the Federal Rules of Criminal Procedure relating to the modification of probation, if it is satisfied that such action is warranted by the conduct of the defendant released and the interest of justice. So actually, the provisions of the federal rules relating to the modification of probation do apply. Sorry, bear with me 1 second. Okay, so when we look at the federal rules of criminal procedure relating to the modification of probation, again, that's Federal Rule of Criminal Procedure 32.1C. And I read C1 before, but let me just read that provision C in full, because I think it would be helpful just to have the full context of 32.1C. So Rule 32.1C, again, for the Federal Rules of Criminal Procedure, says modification, and then it says 1, in general. Before modifying the conditions of probation or supervised release, the court must hold a hearing at which the person has the right to counsel and an opportunity to make a statement and present any information in mitigation. 2, exceptions. A hearing is not required if A, the person waives the hearing. I understand that's not the case here. Or, continuing with C2, capital B, the relief sought is favorable to the person and does not extend the term of probation or of supervised release. And capital C, an attorney for the government has received notice that the relief sought has had a reasonable opportunity to object and has not done so. So it's saying a hearing is not required if under C2 capital B, the relief sought is favorable to the person and does not extend the term of probation or of supervised release. And C, an attorney for the government has received notice that the relief sought has had a reasonable opportunity to object and has not done so. And here, the relief sought is favorable to the person and it does not extend the term of supervised release. It's seeking an early termination. So it is seeking relief that's favorable to Mr. Spencer, and it would not extend the term of supervised release, rather than shorten that term. And under 2C, small c to capital C, that portion's not satisfied because an attorney for the government has received notice that the relief sought has had a reasonable opportunity to object and has not done so, is what the rule requires, and that is not satisfied here. That's C2 capital C. So I just don't see that a hearing is required under this rule. But nonetheless, I am holding a hearing now.
Right.
And that E1, ultimately 18 USC 3583 E1 allows me to terminate a term of supervised release early after the expiration of 1 year of supervised release, which is the case here, if it is satisfied, if the court is satisfied that such action is warranted by the conduct of the defendant released and the interest of justice. And I do not find that to be the case here, given that, given the positive test, relatively recent positive test in October. Early termination is something that sometimes people will seek if they've been fully compliant with all the conditions of supervised release. If someone's not been compliant with all the conditions, it doesn't necessarily result always in a formal violation report being filed, but I would not find that early termination is warranted when there's been some violation in the form of a positive drug test. And it's not in the interest of justice to early terminate in light of that.
Can I speak, or is that final? I don't want to interrupt you, but
No, please go ahead.
okay. So just to counter that, I would ask you to reconsider, because again, I've been stating that I did not violate my supervised release conditions. In addition to that, I let probation know that I was using legal cannabis products. When I attempted to talk to my probation officer about it, she told me that that doesn't matter. A failed test or a positive THC test is a positive THC test. And that's simply not true. On top of that, well, I guess nothing on top of that, that I didn't violate my terms of supervised release. Notwithstanding this THC positive test, I was never given a meaningful opportunity to challenge that test, other than my statement that was clearly accepted on its face, that I used legal THC products. I was instructed to get rid of them, which means now I don't even have the legal THC products to present for an investigation. And there's only prima facie evidence that I failed, or that I violated my supervised release conditions. So the government has not satisfied their burden of proof, and they can't do that. So now they're saying that this test is enough, and what I'm hearing is that you're concluding that in the interest of justice, it's not. But I participated in 100% legal behavior, legal conduct. I was upfront about it. I let my previous probation officer know about it. She didn't respond to me for almost 2 years. And now when I asked for early termination of supervised release, the test, which did not have, this is the 4th or 5th test that I've taken. And I feel like the court is just kind of overlooking all of those things. And I would ask the court to reconsider based on that.
Okay, so when you say you were using legal cannabis products,
Yes, ma'am.
I don't know that so even though cannabis is legal in at least some instances, in many instances under Illinois law, under state law, cannabis remains illegal under federal law. And I think it's a common source of confusion for people who are under supervised release, that even though cannabis is legal under certain states' laws, including Illinois, it remains illegal under federal law. And so I don't know whether, do you have any argument that it's legal under?
Yeah, I do.
It simply is not.
Oh, okay. So the 2018 Farm Bill legalized THC products, certain THC products. Those THC products have to have a THC threshold under the controlled substance limit, but they can still cause positive drug tests. I told probation that I was using legal THC under the hemp farm bill, specifically talked about the legality that this was made legal by Congress, an act of Congress. My conditions specifically say controlled substances. The Hemp Act of 2018 made those substances no longer controlled substances. The probation told me to get rid of them, didn't investigate, and they only have a THC positive test. They ignored what I told them, didn't want to look at my evidence, gave me no meaningful chance to oppose it. Now they don't want to file a formal violation where I can have a meaningful chance to oppose it. And we're saying that I violated my supervised release conditions. There's not enough evidence for that. Probation could have said, well, what did you take? Let me see. They could have said, I could have admitted, I took cannabis, but I didn't. I told them specifically what was going on. I told them this before Leslie Culp was my PO. And there was never any issue about this until I asked for early termination of supervised release. And that's my argument, that Congress, by an act of Congress, this is not a controlled substance. And there's only prima facie evidence at best, but there's no preponderance of the evidence that I failed my test, given what I told probation, given that they didn't want to investigate it. This is just, like taking a test and saying my conditions do not ban THC and they don't ban alcohol. So if you're going to construe my conditions liberally or like narrowly in my favor and not expand them to say something that they don't, and then I say, look, this is legal THC, I could fail this test. I told them this again on October 7th, even before the test came back. And then they don't investigate it, but yet try to get me to say that I used a controlled substance, and I maintain that I haven't. I'm going to potentially be punished for legal conduct with no investigation at all, for conditions that don't say that, and then for an act of Congress which legalized the products that I had. I think you should reconsider based on that. I think that that's a strong argument.
Okay, so I mean, I don't at this. So first of all, let me just say, you've mentioned at different times that the government has the burden of proof. It is actually the defendant's burden when it comes to early termination of supervised release. So the case United States versus George, 534 F. 3rd, 926, 927, Northern District of Illinois, 2021, that says early termination of supervised release is not an entitlement. Instead, quote, the defendant bears the burden of demonstrating that early termination is warranted, end quote. Again, that's from George, 534 F. 3rd at 927. So the burden is on the defendant to demonstrate that early termination is warranted.
Okay.
And I would need, I would need confirmation of what products he took. I would need also more information about how those products actually, or were they actually legal under federal law. You've described in the hearing today the Farm Bill, but it's, I don't have in front of me actual briefing on that issue. And so I'm just not in a position to make a finding today.
Okay, so if the burden is on me, can I ask a question real quick just to kind of clarify? You said that you don't have the Farm Bill in front of you. I get that. I did touch on that in my pleadings. I did list the Farm Bill. And you said also that you would want to see, what products did I have. What has to be understood here is that I was instructed to get rid of all of my products, and probation didn't even want to entertain what I was trying to tell them. So now you're saying that the burden of proof is on me and I get that, but I guess can't we delineate between like where that burden goes to and where it ends? Because they didn't give me a violation, and I'm saying the interests of justice weigh in my favor for all the time that I've been on it. I've complied. I've made my restitution payments. I understood my supervised release conditions. I read them. I had to sign them. I was told these are what govern you from the very beginning. And then when I go to enact those or to rely on those and rely on the explanations that I've been given in the past, and then also the silence is consent principle, where they didn't say anything to me about any problem with legal THC until I asked for early termination, and now they're telling you that I tested positive. I hear you, but I don't think that I should have to now prove, or you should at least acknowledge the prejudice to me proving what products I would have taken back in October when we're in March, and they told me to get rid of them and didn't even want to entertain that. Like, that's valid. You should have seen the products. That should have been documented. And I tried to present that evidence then, and I was told under threat of more violations to get rid of it. So do you see how that prejudices me trying to prove this now?
I just am not in a position to make a finding on that either.
Okay. So it sounds like to me maybe there'd be maybe an opportunity for more briefing or more arguments on that.
I'm sorry, did someone else want to jump in?
I think so.
Yes, Judge. This is Leslie with probation. Thank you. I just want to put on the record, Mr. Spencer was never told dispose of those products, get rid of those products. It was just said, cease using those products. You need to stop using them. You cannot use those products moving forward. And he understood that. That's all.
And okay, Judge, I will tell you that that's completely untrue. I would be more than happy to impeach that witness at the appropriate time, but I was instructed to get rid of them, and that's what I did, under threat of being caught with them being violated for having these legal products. So, that's how I would respond to that. And it definitely prejudiced me now. The other thing is that's why the 35 or maybe 3603, all of my discovery stuff, it should be written down in these records what I told her on October 7th. And when you look at all the written records, I promise you that it weighs in my favor what I'm saying. Exactly what happened is what happened.
Let me just return to the basic point, which is that early termination of supervised release is not an entitlement. So the sentence that was imposed, I was not the sentencing judge. The sentencing judge was in the District of Minnesota. But the sentence that was imposed included a 5-year term of supervised release after a total of 125 months of imprisonment, which was different sentences running concurrently, but ultimately it was 125 months of imprisonment followed by 5 years of supervised release. And that's the sentence that is in place. Again, early termination of supervised release, there's no right to it. And so when you keep saying there's prejudice to you, that's not.
Oh, okay.
I understand your argument is that you wanted to file for, or you did file for early termination, and you are arguing that you lacked all the evidence. You now lack all the evidence you would have liked to present in support of that petition. But number one, the probation office says that you were never instructed to dispose of products, just continue using them. And number two, regardless of what happened there, it doesn't really matter because early termination again is not an entitlement. It is something that the court may do. So going back to the statute, 18 U.S.C. 3583E, it says the court may, after considering various factors set forth in various subsections of Section 3553, A1, A2B, A2C, A2D, A4, A5, A6, and A7, terminate supervised release early, essentially, at any time after the expiration of 1 year of supervised release, if it is satisfied that such action is warranted by the conduct of the defendant released and the interest of justice. And so all of that, what can get lost in that is that it starts off with the word may. The court may terminate supervised release early.
Understood.
So first I have to make the finding that the action is warranted by the conduct of the defendant release and the interest of justice, and then I need to consider all these factors set forth in Section 3553, A1, A2B, A2C, A2D, A4, A5, A6, and A7. And then I may terminate early but it's a discretionary decision, and it's not a right. And so I am not satisfied that that the early termination is warranted by the conduct of the defendant or the interest of justice. And even if I were, I have enough concerns having now sat through this hearing that I just don't. I don't find that the interest of justice is satisfied.
Can I ask you to kind of articulate why that is? If I didn't, are you saying then that the evidence is that I violated my supervised release? I guess I'd like some clarification on that. That's what you're ruling. Because, I guess I just need some clarity then if I'm going to appeal. And then if you could articulate why you say the interests of justice aren't. Because I think short of that, the prosecutor or the government saying that I tested positive for THC, I don't think you would say that.
So I don't find that there's not been a sufficient coherent demonstration of how the products that you claim are legal under federal law are in fact legal under federal law. I understand that perhaps they're legal under Illinois law, but you've not presented a coherent case that they're legal under federal law. You've mentioned the Farm Bill, but it's not clearly teed up. It's just you flagged it in the hearing. You may have flagged it in some of your filings, but you've filed so many filings that it simply doesn't tee up the issue clearly. It's just based on even a quick internet search, it looks like the DEA says that a lot of THC products are still illegal. So I just find that it's not been clearly teed up.
Well, I have
your point.
I did.
Please don't interrupt the judge, sir. Please don't interrupt.
Okay, excuse me. I'm sorry.
And so I am not convinced that these products are actually legal. And you also haven't identified what the products are. It's clear that you did test positive for THC, at least, in October. We're now in March. That's reason enough that I do not find that the interests of justice are served by an early termination.
Okay, I don't want to interrupt, so I'm not saying anything. May I speak?
1 second,
Oh,
please.
okay.
Okay. I'm also required under 3583E to consider the factors set forth in Section 3553A1, A2B, A2C, A2D, A4, A5, A6, and A7. And just to go through those factors, that would be 3553A1 is the nature and circumstances of the offense and the history and characteristics of the defendant. A2B is the need for the sentence imposed to afford adequate deterrence to criminal conduct. A2C is the need for the sentence imposed to protect the public from further crimes of the defendant. A2D is the need for the sentence imposed to provide the defendant with needed educational or vocational training, medical care, or other correctional treatment in the most effective manner. A4 is the sentencing guidelines, essentially the kind of sentence and the sentencing range established for the applicable category of offense committed by the applicable category of defendant as set forth in the guidelines. And then 4B is in the case of a violation of probation or supervised release, the applicable guidelines or policy statements issued by the Sentencing Commission. As already discussed, there's not an actual violation that's been reported. A5 is any pertinent policy statement issued by the Sentencing Commission. A6 is the need to avoid unwarranted sentence disparities among defendants with similar records who have been found guilty of similar conduct. And A7 is the need to provide restitution to any victims of the offense. So I would find that even if everything you've said is true, that you did not actually violate the conditions of release, I would find that considering all the circumstances and all those factors that I just walked through from 3553, which are enumerated in 3583E, and in particular, the nature and circumstance of the offense and the history and characteristics of the defendant, and the need for the sentence imposed to afford adequate deterrence to criminal conduct, I would not find that an early termination is appropriate here. It was a serious offense. Although I was not the sentencing judge and the sentence occurred in the District of Minnesota, just reviewing the materials, or the docket that is on in this docket, those refiled in this docket. It's at docket 2 of our docket. As I mentioned before, there was a very substantial sentence, a term of 125 months, consisting of certain concurrent terms, followed by 5 years of supervised release. The underlying offenses were conspiracy to commit mortgage fraud through interstate wire and to commit bank fraud, mortgage fraud through interstate wire, bank fraud, and engaging monetary transaction in criminally derived property. The length of the sentence reflects the seriousness of the offense, and I do not, again, early termination is, there's no entitlement to it. The existing sentence includes a 5-year term of supervised release, and and I just would not find that in light of the in light of the underlying I would say, in light of, so just to be clear, it's 3553A2A is not among the factors that's listed in 3583E. So it needs to be confined to 3553A1, which is the nature and circumstances of the offense and the history and characteristics of the defendant, and the other enumerated factors in 3583E. So that would be 3553A1, which I just mentioned, as well as, among others, 2B, A2B, to afford adequate deterrence to criminal conduct. And so I would find, so let me just clarify, I'm not considering 3553A2A, which that's the seriousness of the offense, to promote respect for the law and to provide just punishment for the offense. Rather, I'm considering 3553A1 and 3553A2B, and considering those factors, the nature and circumstance of the offense, the history and characteristics of the defendant, and A2B to afford adequate deterrence to criminal conduct. I don't find that, even if the early termination were warranted by the conduct of Mr. Spencer and the interest of justice, or let me just strike it. Even if I were satisfied that early termination were warranted by the conduct of Mr. Spencer, even if he had complied with every condition of supervised release, the interest of justice would not be satisfied based on 3553A1 and A2 capital B at a minimum, as well as A2C to protect the public from further crimes of the defendant. There is some, there is a need for that, and supervised release serves a purpose in that regard. A2, and I understand that there's only 2 months left, less than 2 months left on supervised release, but there is some incremental benefit even from that, a little bit less than 2 months. And so,
okay.
for all those reasons, not in the interest of justice to early terminate.
If I can ask the court something about their ruling.
Sure, and then we're going
Okay.
to conclude the hearing.
Okay, so you mentioned the seriousness of my crime. I would just say that my crime and then the conditions that I'm alleged to have violated are I'm not on a drug crime. And so then I guess I would ask what other crimes I don't see the public deterrence factor. The court seems to, I'm wondering, has the court overlooked where I've said specifically, and I'm looking at my affidavits, and you are right that there are a lot of things filed, but I feel like I did develop the THC Farm Bill. I was very specific that I used THC of 0.3% or less, all the products. And you said you would want to see that. Well, I was never given any meaningful opportunity to present that. When I offered to discuss that, I was turned down and told that it wasn't, it wasn't going to happen. So now you're saying that the burden of proof is on me, but I've never really had an opportunity to do that. It's almost like by not filing the violation, the government can get out of having to prove their violation, and then they can do what they wanted to do, which is keep me on supervised release. And then you've recited all of those things, but the nature and seriousness of my crime has to do with money laundering and bank fraud and mortgage fraud. It doesn't have anything to do with drugs or controlled substances. So I feel like, again, like that's kind of just being overlooked. And then I did make a motion for summary judgment based on the fact that my conditions do not create a THC ban. So I guess I would ask that you would rule on those motions too.
Okay, so there doesn't need to be, the conduct of unsupervised release doesn't need to be the same conduct that led to the conviction, that's underlying the conviction. So the fact that the conviction was for mortgage and bank fraud and those type of offenses and conspiracy related to those. Yet now the issues that are coming up, whether they're a formal violation or not, relate to potential drug use. That's not a reason to discount the current issues, because supervised release, there's a variety of conditions that are imposed. And if someone is, for example, using drugs, is looking back into drug use, it can present a risk of recidivism. It can present a risk of returning to crimes of various kinds, whether it's mortgage or bank fraud or something else entirely. It is very possible that drug use is not a given, but it is it's a possibility, and it is a risk for recidivism. And so that's why the conditions of release, they include conditions that get at drug use and are an attempt to help people avoid it, because the purpose of supervised release is to try to help people reintegrate into the community after time in custody and to avoid further crimes, to avoid recidivism. And so there are a bunch of conditions that get at those purposes.
That's true.
So it doesn't matter. That it's not a reason to early terminate that.
I'm not saying that it is either, though.
Potential issue on supervised release has. Okay, please don't interrupt.
Okay.
And the second thing I would say is that the motion for summary judgment and temporary restraining order, and there's also an emergency motion for temporary restraining order and preliminary injunction. Those are civil type of motions that that's not a process that's that's just not are not motions that are contemplated under the rules of criminal procedure.
Well, if they're not contemplated under the rules of criminal procedure, then they should be allowed. Because if there's not a rule that negates that, then my understanding is that it does apply in criminal proceedings. If there's no specific rule that says you can't bring those motions could be appropriate. So that's why I brought those motions. So I don't see where I'm prohibited in any rules from bringing those motions, even though it's a criminal proceeding.
Okay. Well, they're just not. There's also not something where I could grant a judgment. So, for example, like motion for summary judgment, there's not. It just doesn't. That's not a recognized next step. Also. Let me just add another site by way of illustration of the complexity of the legal issue as to whether hemp or THC as to the status of THC. So AK Futures LLC versus Boyd Street Distro LLC, 35 F4 682 699, Circuit 2022, has a discussion of the Farm Act and
I'm glad you brought that up.
THC, except in hemp, is still a Schedule I controlled substance under 21 U.S.C. 812 C17.
Mm-hmm. It is.
Okay. Okay, so just to summarize and conclude, the motion for early termination denied. That's docket 3. In addition, there are other motions that are pending, all which I will deny. That's docket 6, 8, 9, 13, 14, and 17. All right, that concludes the hearing. Thank you, everybody.
Thank you, Judge.
Take care.
Thank you, Judge.
Bye.